problem that arose time and again. This will answer that question. Entries aforementioned disclose the following features. They refer to those entries, not entry 33, 52, Lordship can see in the earlier paragraph. Entry 8, paragraph 23. We may now notice the relevant entries in our Constitution. Entry 6, 8, 6, 24, 51 in list 2 of the 7th schedule to the Constitution read thus. Lordships have already seen, so I will not waste Lordship's time on that. Entry 33 in list 3 was substituted by Constitution 3rd Amendment Act 1954. The background to this entry is explained by this court in Tikaramji versus State of UP. Entry 33 of list 3 reads, trade and commerce in and production, supply and distribution of the products of any industry where the control of such industry by the union is declared by Parliament by law to be expedient in the public interest, and imported goods of the same kind as such products. Foodstuff, edible oil, including cattle fodder, raw cotton, Lordship, but that we are not concerned with that. But foodstuff, Lordship may keep in mind because I'll refer to that later on. The entries aforementioned disclose the following features. The power to make a law with respect to industries lies with the states. Entry 24, list 2. But the said entry is made expressly subject to the provisions of entry 7 and 52 in list 1. It means that if Parliament declares by law that it is expedient in public interest to take over the control of a particular industry or industries, such industry or industries get transplanted to list 1. In other words, the industries in respect of which Parliament makes a declaration contemplated by entry 52 in list 1, the states are denuded of the power to make any law with respect to them under entry 24 list 2. Parliament has indeed made the declaration contemplated in entry 52 in list 1. In section 2 of the IDR Act, which reads, the declaration as to the expediency of control by the union, it is hereby declared that it is expedient in the public interest that the union should take under its control the industries specified in the first schedule. By an amendment effected in 56, first schedule was amended. The Amendment Act inter alia introduced entry 26 in the scheme. It reads fermentation industry, alcohol, and products of the fermentation industry, other products of fermentation industry. The contention of the learned counsel for the petitioners is based upon these provisions. The submission is that manufacture and production of intoxicating liquor is an industrial activity falling within item 26 of the first schedule to the IDR Act. The IDR Act provides for licensing of industries mentioned in the first schedule to the Act, besides providing extensive control and regulation of such industries and their products. The grant, the renewal, and the refusal to grant or renew the license is thus the exclusive province of the center. The state has no say in the matter. The state legislature is incompetent to prohibit manufacture of intoxicating liquors. But this argument, in our opinion, ignores the existence and the ambit of entry 8 in list 2. Entry 8 expressly speaks of production, manufacture, possession, transport, purchase, and sale of intoxicating liquors. It means that the power to make a law with respect to the said matters rests with the state legislature. What is significant is that the entry speaks expressly of production and manufacture of intoxicating liquors as well. This would mean that the industries producing and manufacturing intoxicating liquors fall within the purview of entry 8. May I pause here? Lordships must keep this in mind, that this judgment is under the shadows of synthetics too. It said that you don't have power in respect of industrial alcohol. You can only regulate potable alcohol. So it is under the shadow of that judgment that they are referring to. Applying the well-known rule of interpretation applicable to such situations, special excludes the general. We must hold that the industries engaged in production and manufacture of intoxicating liquors do not fall within entry 24, but do fall within entry 8. This was the position at the commencement of the Constitution, and this is the position today as well. Once this is so, the making of a declaration by Parliament as contemplated by entry 52 of list 1 does not have the effect of transferring or transplanting, as it may be called, the industries engaged in production and manufacture of intoxicating liquors from the state list to union list. As a matter of fact, Parliament cannot take over the control of industries engaged in the production and manufacture of intoxicating liquors by making a declaration under entry 52 of list 1, since the said entry governs only entry 24 list 2 but not entry 8 list 2. Faced with the above position, learned counsel for the petitioner resorted to more than one argument to get over it. Firstly, it was submitted that the entries 24 and 8 should be read harmoniously, and that such harmonious reading should mean that the industries engaged in production and manufacture of intoxicating liquors would fall within entry 24, because entry 24 deals with industries as such, while entry 8, according to such reading, would be confined to matters other than production and manufacture of intoxicating liquors. It is not possible to agree with a submission which run counter to the express language of entry 8. It requires us to delete the word production and manufacture from entry 8, which is not open to us. We cannot rewrite the entry. Another limb of this argument was that only those entries manufacturing intoxicating liquors which are not within the purview of IDR Act will fall under entry 8. Now, can you see the reading the definition of industrial undertaking clause D and the defining of factory in clause C of section 3 of the IDR Act, it is submitted that the two types of industries are not covered by IDR Act vis-a-vis those where manufacturing process is carried on, one, with the aid of power but with less than 50 workers, and without the aid of power with less than 100 workers. The submission is that these industries which are not within the purview of IDR Act would remain within the purview of entry 8, while the other industries would be under the control of the union. This argument is equally unacceptable. This argument is premised on the assumption that entry 52 in list 1 overrides entry 8 in list 2, as which assumption, as we shall presently point out, is without a basis and unacceptable. Moreover, industries which are exempted from IDR are exempted because the very provision of the IDR Act and not by virtue of entry 8 in list 2. The ambit and scope of constitutional entry cannot be determined with reference to the parliamentary enactment. The definition of factory in clause C of section 3 of the IDR Act may be changed tomorrow. The meaning and scope of entry 8 in list 2 does not and cannot vary with the change in the provisions of IDR. This submission too is therefore unacceptable. It was then contended that entry 52 list 1 governs not only entry 24 in list 2, but all other entries in list 2, including entry 8, insofar as it deals with industries. We cannot accept this submission either. A perusal of list 2 would show that whenever a particular entry was intended to be made subject to an entry in list 1 or list 3, it has been so stated specifically. Not one but several entries in list 2 are made subject to one or the other entry in list 1 or list 3. See entry 2, 13, 17, 22, 23, 26, 27 and 33. Certain other entries use a different phraseology to demarcate the sphere of the union and the state. For example, entry 32 in corporation, regulation and winding up of the corporation, other than those. Likewise, note entry 51 list 2. All this shows that whenever a particular entry in list 2 is sought to be made subject to another entry in list 1 or 2, or where a demarcation is sought to be made between union and the states within a particular head of legislation, the founding fathers have taken care to say so expressly. We cannot therefore accept the argument of the learned counsel for the petitioners in that entry 52 in list 1 impinges upon, overrides and governs entry 8 in list 2 as well. It does not. We must make it clear that entry 8 speaks of only intoxicating liquors and does not therefore apply to or take in liquors which do not fall within the expression intoxicating liquors. The power to make a law with respect to production and manufacture of intoxicating liquors is that of the state alone, the prohibition of production and manufacture of intoxicating liquors 2 squarely falls within four corners of entry 8, read with entry 6 of list 2. This was the decision of the Constitution Bench in Code Distillery. Article 47, then they refer to, then Lordship have, they refer to
37, straight away.
37.
Yes.
Man,
That will cover Kolkata Gas Company.
my lord, I'm great.
Not read again, but
We may, in this connection, and this is the first case where this principle was evolved.
Correct.
We may, in this connection, refer to Constitution-based discussion, this decision of this court in Calcutta Gas versus State of West Bengal, which furnishes a complete answer to the petitioner's contention on this court. The West Bengal legislature passed an act, West Bengal Oriental Gas Company Act 1960, with a view to take over the management and control of the undertaking of the Oriental Gas Company. Notifications were issued under the act taking over the company, which was questioned by way of a writ petition in Calcutta High Court. The writ petition was dismissed, whereupon the matter was brought to this court. The main contention on behalf of the appellant was that the West Bengal legislature has no legislative competence to enact the said act. It was submitted that by virtue of Industries Development Regulation Act 1951, which contains a declaration in terms of entry 52 in list 1 and the schedule thereof included fuel gas, coal gas, natural gas, and the like. Under item 2.3, the power to make law with respect to those industries engaged in the manufacture of gas has been vested in the union, and that state has been totally denuded of that power. It was contended that entry 24 in list 2 takes in all industries, and that entry 25, which reads gas and gas works, should be confined to matters other than those covered by entry 24. Inasmuch as impugned enactment was a law relating to gas industry, it was submitted the act made by the state legislature is incompetent and void. Reliance was also placed upon Article 246 of the Constitution. All these contentions were negatived after referring to the provisions of IDR Act and the impugned West Bengal Act, the relevant entries in the 7th schedule to the Constitution, including entries 7 and 52 in list 1, entries 24 to 27 in list 2. And the principle governing the interpretation of the entries in 7th schedule, the court indicated that the matter was susceptible to 3 possible constructions. Entry 24 of list 2, which provides for industries, generally covers the industrial aspect of gas and gas works, leaving entry 25 to provide for other aspects of gas and gas works. Entry 24 provides generally for industries, and entry 25 carves out of it the specific industry of gas and gas works, with the result that the industry of gas and gas works is excluded from entry 24. And 3, the industry of gas and gas works falls under both the entries, that is, there is a real overlapping of the said entries. The court opined that having regard to the well-settled principles relating to interpretation of these entries, that interpretation which reconciles and harmonizes the contending entries should be adopted and held. And entry 24 in list 2, in its widest amplitude, takes in all industries, including that of gas and gas works. So too, entry 25 of the said list comprehends gas industry. There is therefore an apparent conflict between the 2 entries, and they overlap each other. In such a contingency, the doctrine of harmonious construction must be invoked. If industry in entry 24 is interpreted to include gas and gas works, entry 25 may become redundant. And in the context of succeeding entries, namely entry 26 dealing with trade and commerce, and entry 27 dealing with production, supply and distribution of goods, it will be deprived of all its content and reduced to useless lumber. On the other hand, the alternative contention enables entries 24 and 25 to operate fully in their respective fields. While entry 24 covers a wide field, that is the field of the entire industry in the state, entry 25 dealing with gas and gas works can be confined to a specific entry, that is the gas industry. It is therefore clear that the scheme of the harmonious construction suggested on behalf of the state gives full and effective scope of operation for both the entries in their respective fields, while that suggested by the United Council for the appellant deprives entry 25 of all its content and makes it redundant. The former interpretation must therefore be accepted in preference to the latter, in this view, gas and gasworks are within the exclusive field allotted to the state. On this interpretation, the argument of the Attorney General that under 246 of the Constitution, the legislative power of state is subject to that of the Parliament, ceases to have any force for the gas industry as outside the field of legislative field of Parliament and is within the exclusive field of the legislature of the state. We therefore hold that the impugned act was within the legislative competence of the Bengal legislature and was therefore validly made. The court proceeded to hold further. Lordship, over the rest, it's a repetition rest mode. When then again, the ratio of the above decision fully supports what we have said here and before. In fact, entry 8 is more specific than entry 25 in list 2, while entry 25 merely speaks of gas and gasworks. Entry 8 expressly speaks of production and manufacture besides possession, transport, purchase, and sale of intoxicating liquors. The ratio of Calcutta gas case fully supports our conclusion that the industries engaged in production and manufacture of intoxicating liquors are outside the purview of entry 24 and fairly squarely fall within entry 8 in list 2, and that entry 52 in list 1 does not override or impinge upon entry 8 in list 2. According to this decision, the expression industry in both entry 24 and entry 52 in list 1 must carry the same meaning, which means that if a particular industry is not within the purview of entry 24 in list 2, it would not equally be within the purview of entry 52 list 1. The decision also supports our conclusion. Article 246 cannot be invoked to deprive the state legislature of the powers inhering in them by virtue of entries in list 2, to wit, once an enactment in pith and substance is relatable to entry 8 in list 2, or for that matter, any other entry in list 2, Article 246 cannot be brought in to yet hold that state legislature is not competent. Now, what is important here again is what is Lord, what is important is not that all these decisions are based on what we call the word industry. Not one word industry in entry 24, as the judgment say, has the same meaning as in entry 52. But what is the scope of this word industry? And that is where Tikaramji is the locus classicus.
Yes.
Which is 1956. Is it 1956 SCR 393 volume. PDF page 80. 80. And this Tikaramji's case still holds the field. And
Mr. Dwivedi, you read, we discussed Calcutta Gas Company, right? That is volume 5, page PDF 2149. Just come to that judgment, para 9, where Tikaramji is elaborately discussed.
Yes.
That will give a fair idea.
Lordship's right, no? Tikaramji was considered by Calcutta Gas, no? And that is for the word industry.
9, para 9 at PDF 2158.
I'm grateful.
About
2158.
15 lines
2158, right.
in the
Para 9.
descending order.
First question that occurs, if I may place, no?
Yes.
Lordship's permission. The first question that occurs to one.
Because this thing, which page you are reading in volume?
2158. PDF page 2158.
9.
Volume 5.
2150.
2150.
2150.
Yeah. And we are at 2150.
2158.
PDF page 2158, which is
PDF 215.
that's a whole confusion. Page. The first question, if I may place here. May I place it?
Yes.
The first question that occurs to one's mind is, what is the meaning of the expression industry in entry 24 of list 2? Is it different from the meaning of that expression in entry 52 of list 2? Whatever may be its connotation, it must bear the same meaning in both the entries, for the two entries are so interconnected that conflicting or different meanings given to them would snap the connection. Entry 24 is subject to the provisions of entry 7 and 52 list 1. Entry 7 of list 1 provides for industries declared by Parliament by law to be necessary for the purposes of defense or for the prosecution of war. And entry 52 for industries, the control of which by the Union is declared by Parliament by law to be expedient in the public interest. Therefore, ordinarily industry is in the field of state legislation, but if Parliament by law makes a relevant declaration or declarations, the industry or industries so declared would be taken off its field and passed on to Parliament. In the premises, the expression industry in all the entries must be given the same meaning. Now, what is the meaning of the word industry? In Tikaramji state of UP, the expression industries is defined to mean the process of manufacture or production and does not include the raw materials used in the industry or the distribution of the products of the industry. It was contended that the word industry was a word of wide import and should be construed as including not only the process of manufacture or production, but also activities antecedent thereto, such as acquisition of raw material and subsequent thereto, such as disposal of the finished product of that industry. But that contention was not accepted. It is not necessary in this case to attempt to define the expression industry precisely or to state exhaustively all its ingredients. Assuming that the expression means only production or manufacture, would it take within its sweep production or manufacture of gas? Entry 24 in list 2 in its widest amplitude takes in all industries, including that of gas and gas works. So too, entry 25 of the said list comprehends gas industry. There is therefore an apparent conflict between the two entries and they overlap each other. In such a contingency, doctrine of harmonious construction must be invoked. Both the learned councils accept the principle while the learned Attorney General seeks to harmonize both the entries by giving the widest meaning to the word industry so as to include the industrial aspect of gas and gas works and leaving the other aspects to be covered by it. Not rest, not I may not place because it's covered under the McDowell, the Lordship have already seen that. But the critical part in Tikaramji's consideration is not entirely here. And therefore, what I want to do is not to cut short time instead of reading all those decisions. There are at least 5-7 constitution benches in that sphere. So it will be wasting time. There's one judgment of a lordships which deals with all of them, Lord, and synopsizes all those cases. Right from Tikaramji onwards till ITC, this judgment. And this is still holding the field, Lord. There's no dispute with regard to this.
Were you referring to this? I was reading the original Tikaramji.
Industry in the wide sense of the term would be capable of comprising three different aspects. Were you reading that part?
Yes.
I'm on Tikaram.
No, that was very well dealt with in Tikaramji. All the matters, all the aspects of industry, they noted
If
one.
you see para 24 at volume 5, page 96, volume 5, Tikaramji begins at page 80. Yes. And if you see para 24, actually that's a crucial part of Tikaramji. See there, the question was whether the process of acquiring sugarcane, which was a raw material for the manufacture of sugar, whether that would be covered within the ambit of industry.
That they said would fall as goods under entry 26.
So just
and
let's
25.
see that para 24 is important actually at page 96, PDF page 96.
Yes. The passage begins as, it is clear therefore,
Page 88.
Yes.
I have lots of cut.
Yes.
It is clear therefore that all the acts and the notifications issued thereunder by the center in regard to sugar and sugarcane were enacted in exercise of the concurrent jurisdiction. The exercise of such concurrent jurisdiction would not deprive the provincial legislature of similar powers which they had under the provincial legislative list. And there would therefore be no question of legislative competence. Incompetence qua the provincial legislatures in regard to similar pieces of legislation enacted by the latter. The provincial legislatures as well as the central legislature would be competent to enact such pieces of legislation, and no question of legislative competence would arise. It also follows as a necessary corollary that even though sugar industry was a controlled industry, none of these acts enacted by the center was in exercise of its jurisdiction under entry 52 list 1.
Now actually what follows is very important.
Right.
After now. Industry in the wide sense.
In the wide sense. Industry in the wide sense of the term would be capable of comprising three different aspects. One, raw materials, which are an integral part of the industrial process. Two, the process of manufacture or production. And three, the distribution of the products of the industry. The raw material would be goods, which would be comprised in entry 27 of list 2. The process of manufacture or production would be comprised in entry 24 of list 2, except where the industry was a controlled industry, when it would fall under entry 52 list 1, and the products of the industry would also be comprised in entry 27 of list 2 as goods. Except where they were the products of the controlled industry, when they would fall under entry 33 list 3. This being the position, it cannot be said that the legislation which was enacted by the center in regard to sugar and sugarcane would fall within entry 52 of list 1. Before sugar industry became a controlled industry, both sugar and sugarcane fell within entry 27 of list 2. But after declaration was made under entry by Parliament under 1951, in 1951 by Act 65 of 51, sugar industry became a controlled industry, and the product of that industry, vis-a-vis sugar, was comprised in entry 33 of list 3, taking it out of entry 27 of list 2. Even so, the center as well as the provincial legislatures had concurrent jurisdiction in regard to the same. In no event could the legislation in regard to sugar and sugarcane be thus included in entry 52 of list 1. The pith in substance argument also cannot be imported here for the simple reason that when both the center as well as the state legislatures were operating in the concurrent field, there was no question of any trespass on the exclusive jurisdiction vested in the center under entry 52 of list 1. The only question that survived being whether putting both the pieces of legislation enacted and the state legislature together, there was any repugnancy in issue. And here they found there was no repugnancy because there was no central law. The conflict has to be in fact, not this is the judgment which for the first time said. There has to be a conflict in fact, and therefore you've got to legislate under the IDR Act to control this. But then the interesting part of it is not this, which Lordship may bear in mind, but kindly come to entry 33. More than that. But there is one interesting factor which Lordships may take into consideration here, Lord, again, which
Difference in Tikaramji was concerned with the control over the antecedent raw material. Over here, we are not dealing with a control over the
That's-
antecedent raw material.
no,
This
no.
is the heart of the industry.
But the
namely
word
industrial
industry
alcohol.
was considered and the scope of word industry was found. No, but important part is why. Question was that was Tikaramji is a case where on the one hand there was
Actually, but for entry 8 of list 2, industrial alcohol would fall within the ambit of industry in entry 52 of list 1.
how would it fall? But this is a question
But for entry 8,
I'm coming to that.
it's an industry.
I'll answer that. No? Then we would at the same time be saying that intoxicating liquor would be only potable liquor and industry pertaining to potable liquor would exclusively go to entry 8.
No. That's not, you have not understood the theory. I'm saying that it is because of entry 8 that
It would not go into
entry that doesn't go into entry 24 and doesn't go into entry 52. But if entry 8 was not there,
then it could have been.
it would have been an industry
Yes,
then within
yes,
entry
yes, yes.
52 of list 1.
Yes, no doubt about it. No doubt about it. Important thing is not entry, the Tikaramji.
Challenging the idea. So what is the ambit
answer.
of the expression
I'll answer that. No?
fermentation?
In
And
Lordship has my lord, kindly again go
the
back.
schedule. You have what is the schedule?
No, there are two answers to what Lordship's query is. No? I'm sorry.
What would be the difference between intoxicating liquor and alcohol?
Not every intoxicating liquor, as per the local acts Lordship has seen, meant all liquids containing alcohol. So every alcohol will have to be there.
Because under the entry 26 of the schedule,
Well, it's a changed entry.
one is
It's a modified entry.
alcohol.
This has been modified in 2016, where because of the Bihar distillery, they carved out an exception not against potable alcohol, which was not there earlier. When these cases were considered, McDowell, Tikaram, the position was entirely different. Only fermentation industry was specified with alcohol, word alcohol.
What was the entry before 16?
That is substituted in
2016.
The only thing within the
Okay.
brackets were omitted.
That's
It
right.
was fermentation
Fermentation
industries and
industries.
then one into the products, alcohol and other products of
products of
fermentation.
fermentation.
Yes.
So other than potable alcohol was added by the
2016, they are in
2016.
It was earlier fermentation industries.
And then
That bracket portion was added.
Products of fermentation industries would take an intoxicating liquor.
Normally, fermentation industry, that was the interpretation given to it. But the whole question is, can you take it? That's a question, can the parliament take it? Now, my lord, to answer, my lord, the Chief Justice's query, my lord, no one has challenged. There's no doubt about it. No one has challenged the inclusion of fermentation industry. There's no doubt about it. But in Calcutta Gas, no one had challenged it. No. Yet the court struck down that on the ground that we are deciding and deciphering the scope of legislative entry. So if the act of another two legislatures do not fall within that entry, then they have to go. The dominant legislature has to prevail. Likewise, my lord, in ITC, again the same thing was done. This objection was raised that no one has challenged the IDR Act. But the whole question would be that if the parliament legislates,
Because if we accept your submission, I mean, not that we are saying that it's wrong, just trying to explore it. That would mean that where any industry is specified in list 2, that would include gas works, that would include intoxicating liquor, that will fall outside entry 52 of list 1.
52 of this.
Isn't
Entry 54 is mines and minerals.
Sorry?
Lordship has done the mines and minerals matter that entry 54 occurs in Lordship's
52.
mind.
No, 52. 52.
52. It would be outside that.
No, but then why does Parliament cover prior to 2016? Parliament covers the entirety of alcohol.
Yes. But the whole issue is whether that is correct or not, because Lordships are defining the scope of the entry and Parliament is legislating on an entry which is not there in their field. So how can legislation without power is a void legislation, still born?
But you're appearing for whom?
State of UP. But we are the petitioners actually sitting on the wrong side, actually. That's the problem.
But are you saying, therefore, that the legislation which
Yes.
is enacted by Parliament is
Otherwise,
void?
we can't get the jurisdiction, Lord. Can you look at it this way? States' jurisdiction has been denied by synthetics on these great grounds, entry 52. Now, if we do not challenge that, synthetics cannot be overcome. If synthetics cannot be overcome, then what are we, due respects, reconsidering? We are considering whether synthetics, when it relies upon entry 52 to shut down states' jurisdiction in respect of intoxicating liquor, which includes industrial alcohol, that is incorrect, and states' jurisdiction cannot be taken away. Synthetics took away because of entry 52 and IDR. Lord, I'll satisfy Lordships on this issue that I need not challenge. If the question arises during consideration, what is the scope of the legislative entry? And if there is any conflict, the Lordship will have to resolve the conflict. And if the Lordships resolve the conflict in the manner I am advocating, perhaps not, then the question would be clear that Centre had legislated absolutely illegally. Otherwise, Lordship would seem, Lord, even though state has jurisdiction under entry 8, yet because of parliamentary declaration or legislation, we are denied the power to legislate on our own field. Lord, whatever is troubling Lordship that no one has challenged IDR, Lord, was answered by ITC.
Legislated
Exactly.
on an industry which falls within the scope of entry 8 of list 2.
Exactly.
Because alcohol.
Well, that is assuming it falls. My lord, industrial alcohol, if it is part of intoxicating liquor, then what Lordship is saying is correct. But if it has, then what will be the consequence? And the aspect that is troubling a Lordship, sir, that since no one has challenged IDR and it has been prevailing, then what can be done? No, that is answered by ITC. We need not challenge it. When Lordships determine the scope of the entries, then the power of the state with respect to its own entry cannot be declined because Parliament has declared something. Otherwise, tomorrow Parliament will take over gas and gas works. Then what happens?
See, because Article 246(1), it begins with a non-obstante clause,
Right.
notwithstanding anything contained in clauses 2 and 3.
Right.
Clauses 2 is with regard to state list. Clauses
Subject
3 is with regard to, clauses 2 is with regard to concurrent list. Clause 3 is with regard to state list. Notwithstanding anything contained in the concurrent list and the state list,
This-
Parliament has exclusive power to do it with regard to union list.
Right. Now, let me explain it not this way. Lordship saw in that case of Lord Jayant Verma, the word notwithstanding is a concept which only emerges when there is an irreconcilable conflict. First, the effort should be to reconcile the conflict if it appears. The Parliament may have legislated on A entry or B entry. But the fact is, what we have to see is whether that legislation is within its field or not. And likewise, state legislation within its field or not. Now, when we find that there are two entries which are overlapping, for instance, industry,
Yes.
gas and gas works, they were overlapping. The court found in McDowell as well as Calcutta Gas. Now, if they were overlapping, then Lordships have to evolve some principles of harmonious construction. Not notwithstanding clause.
The other harmonious way would be to say that yes, the state does have the power over intoxicating liquor,
Quite right.
but once there is a declaration made by Parliament under entry 52,
That power is
then
taken.
your power is denuded.
Then that, which means entry 8, list 2, even though it has not been made specifically subject to entry 52, it becomes subject to like entry 24. So what are we saying is that we are reading word subject to in entry 8, which perhaps it is not open to read.
Then what is the meaning to be given to the expression notwithstanding anything contained
Not,
in
I'll
Article
answer that.
246(1)?
Quite right. I'll answer that. Not notwithstanding means not in case the conflict is irreconcilable harmoniously, then in that even parliamentary entry would prevail over the state entry. But the fact is, when your Lordships can reconcile harmoniously, as Lordships have done in the case of McDowell and Calcutta Gas, then perhaps notwithstanding clause would not operate.
That is the question.
No, but in every case, that's
Whether we can narrow the scope of the expression industry in entry 52 list 1.
not entry 24 list
Entry
1.
52 list 1.
For that, not the answer was there in this McDowell's case. Entry 52 draws from entry 24. Now, what we have to see, what is the position in the state list with regard to word industry in the state list. Now, in the state list, industry means what that has been determined in Calcutta Gas as well as McDowell. It means only manufacture.